More stories before we go. Private legal practitioner Francis Kwarteng Arthur has dragged the National Communications Authority (NCA), the Ghana Telecommunications Company Limited operators of Vodafone Ghana and Sancom PLC operators of MTN Ghana, Airtel Ghana Limited, and the Attorney General to an Accra High Court. He alleges that the NCA, by requiring the telcos to procure, store, or use his personal information, including his fingerprint, palm print, iris, or facial pattern record, or other biometric data or particulars, has infringed on his rights. Administrative justice, property, speech, information, and privacy will also be violated. He is therefore asking the High Court to make an order to set aside the directive, instruction, or requirement imposed on the mobile network operators by the NCA to procure such personal information. He also wants the NCA and the telcos to be restrained from authorizing, directing, instructing, or requiring the collection, storage, and use of his personal data. And joining me via Zoom is my colleague Kweku Asante with details of that writ filed there. Kweku, what more has he been saying in that writ in terms of the reliefs seeking from the court?
All right, Ernest. So this application is in two legs. First is praying the court to grant an interlocutory injunction. We know that the National Communication Authority, together with the networks, are planning to end this whole exercise March 2022. So his prayer is that the National Communication is insisting that if all users of SIM cards do not re-register their SIM, then they will lose their SIM cards forever. And so he is saying that pending this determination of this suit, which may travel longer than March next year, the High Court should grant an interlocutory injunction until this suit is determined before the exercise can continue. And he's been praying through his lawyer, Justice Shremsai, that the action of the National Communications Authority together with the telcos is one that breaches his fundamental human rights. He speaks about his human rights. He talks about the idea that these telcos can't store his biometric details as well as other personal information without his consent. And so he's insisting in this suit that the court should grant an interlocutory injunction until this case is dealt with. And so that is the first leg that I've just revealed to you. But these are the key issues he is seeking from the court, the remedies and the reliefs he's seeking. He wants the court to adjudge that by directing, instructing, or requiring mobile networks, including the respondents, to procure, store, or use my personal information, including my fingerprint, palm print, iris, or facial pattern or record, is likely to violate my fundamental human rights to administrative justice, to property, to speech, to information, and to privacy. It continues that he wants an order of certiorari directed to the first respondent, that's the National Communication Authority, to bring up to this honorable court for the purposes of being quashed and the question of his directive, instruction, or requirement to mobile network operators to procure, store, or use my personal information. He wants also an order of cost and an order of perpetual injunction restraining the respondents from continuing with this exercise. So essentially, this private legal practitioner is in court trying to argue that the National Communications Authority, the Attorney General, and the telecommunication networks and their insistence on Ghanaians re-registering their SIM cards is something that breaches their fundamental human rights to owning property, to speech, and also it's something that does not augur well for the laws of the Republic, and he wants the court to strike that out.